Those of you on speaker so that we'll hear them.
TAT/ID/0/2022. Federal Revenue Service. Was of State Government, Accountant General of States, and Accountant General of the Federation. Five. One.
Click on the three dots. Click on the three dots.
Oh, it's okay.
Yeah.
It's okay.
I did that one. That's it.
Please witness unmute yourself. Parties,
Actually, I'm not after.
please allow yourself.
Mrs. Oduya, let's announce yourself as representing the appellant.
Good morning, stars. My name is Oduyale Taiwo Oluwafunmilola. Deputy Manager Tax, representing Nigerian Revenue Service.
Yeah.
With all respect to the Sorry Traveler, Aisma Abdurrahim.
That's somebody else happens.
With me, your honor, is F.A. for Chalet. Our humble appearance is for the appellant. We are most grateful. What's separate for us? Councilor for the Council Separate. All of us.
They're absolutely. What should I go to appearance? Yeah, no, I'll be. Yes, I'll be.
With profound respect to this honorable tribunal, the third respondent, Abimbola Akinifesi. For the third respondent, appearing with me is Deborah Obidima. For the third respondent.
Who is with you? Deborah what? Who is with you? Who is appearing with you?
Okay, Deborah Obidima.
Okay. Yo. I'm not saying for the first time, letter, written by first and second person. However, that was first time. I'm just saying for the first time, letter written by first and second respondents. Council. Although we don't feel that first one was having this directional of this one in the tribunal. He mentioned to me that she had written a letter seeking for and then that there is no complaints for her. I'm just saying for the first time. So in the circumstances of ordinary, the last time we had our trial and our witness was having to examine like first and second respondent counsel. So left for the third respondent counsel. But in view of the absence of first and second respondent counsel, I wouldn't know the line the honorable tribunal wants to. So because the counsel to third respondent is. Yeah, we are judged for possible examination on the last adjournment for the third respondents counsel. Correct. So cross examine the witness as tribunal process. So if you said, I see no reason why we will not proceed. We are in that.
We are ready, my lord.
Is that Fesi?
Yes, Mr. Chairman. We are ready.
I read the record of proceedings.
Have I?
I read the record of proceedings for the days when you were absent from the tribunal.
I was only informed that we are to cross-examine the appellant today, and we are ready.
Where were you informed?
Mr. Chairman, it's been a while, over 2 weeks.
Did you receive an email from the registry about the proceedings at the last adjournment?
About what?
About the proceedings at the last adjournment. Did you read?
Yeah, I received from Mr. Tolu.
So did you read what transpired at the last adjournment? Because I don't know why you could understand now. Issue are not here. And if you did not read the record of those things.
Mr. Chairman, I can't hear you.
What do you want to cross-examine now if you have not read the record of those things?
What was the what?
Okay. Let me repeat myself. At the last adjournment, the applicant's witness gave her evidence under examination in chief. She was cross-examined by the counsel to the first and second respondents. They were absent. The tribunal gave a ruling which we directed should be served on you to let you know that we proceeded with hearing of the case despite your absence. And I'm asking you this morning, you said you are ready for cross-examination. Have you read the record of proceedings at the last adjourned days? Did you know?
Mr. Chairman, I may need to read it again.
You need to read it again.
I can't recall what was there. I just make sure I took note of the next day. So I may need to read through. I just took note of the next adjourned date. I can
I
remember
will
the
need to do. I will need to read the directives given at the last adjourned dates. And this was served on you. Okay, so if you are now feeling not knowing what transpired the last adjourned date, I will read it.
I would need, that's why I said I will need to read through, but I remembered it stated that the matter will be coming up today and that we are to cross-examine the appellant's witness.
That is all you remember. And then you said that this morning that we are ready to cross-examine when you have not read the record of proceedings to know what happened on the last adjourned date. Or is first examination not supposed to be based on examination in chief? The evidence given by the witness on the examination in chief. We ask you a question. This is Agriface.
Yes, Mr. Chairman.
Did you receive an email from this tribunal to which was attached the directives given by this tribunal at the last hearing date?
Okay. Mr. Chairman, I didn't hear you.
My question to you,
Yes, Mr. Chairman.
did you read the orders given by this tribunal, which was transmitted to you via email?
My lord, we didn't breach. We on the last adjourned, we wrote to the tribunal. My lord, we don't intend to disrespect this tribunal. We reached out via email that for a convenient date, and at the end of the day, we got a date that wasn't convenient, and we were in court on another matter. We always reached out to the court via email. We never intend to disrespect this tribunal. The emails are there. It speaks.
We'll read your emails to you so that you can understand why the tribunal did not wait for you. Okay, so that you can understand why the tribunal did not wait for you. Why we discuss your application for adjournment. So that's why I told you, if you receive the email and you are feeling as if you did not receive the email, we'll read out to you the orders you gave on that day. So that you can understand. Now, this morning, we wanted to cross the subject. We're asking you, have you read the record of proceedings? We have not read the record of proceedings. And we're asking you, what do you want to cross the subject on?
Oh, we can, Mr. Chairman, if you can stand down for a few minutes so that we'll go through the email just to refresh my memory of the last proceedings.
So you came to the tribunal prepared, and yet you wanted to cross examine. That is, if you miss appearance in court, and the tribunal gave directives which we directed should be served on you to let you know that hearing proceeded, and that today, which is the next adjourned date, that you will be cross-examined the witness. Must you not ask for the record of proceedings before now to know the evidence that the witness gave?
My lord, if you could stand down for 10 minutes so that we read through the ruling. It's the ruling that was served on us, that was sent on us to us.
I beg your pardon?
I said if you could stand down the matter for 10 minutes, we got a ruling was sent to our WhatsApp.
You have to repeat yourself because no one heard you.
I said a ruling was sent to our WhatsApp showing today's date. So we could read through it. Maybe we could stand down for 10 minutes just to read through it.
Okay, so you received the message, whether by WhatsApp or by email. You didn't read through. What you just read through there was that the case was adjourned today for your cross-examination. That's what you just read there. And as a counsel, you didn't know that you asked for the record of proceedings.
Sent me a message via WhatsApp informing me as well.
Repeat yourself because we couldn't hear you.
I said the first and second respondent sent me a message via WhatsApp that's to cross-examine the appellant. I still have the message on my phone
So it was the first and second respondents that communicated
for
with you.
today.
Did not receive any communication from the registry? Are you saying you did not receive any communication from the registry? Hello? Are you saying you did not receive any communication from the registry, no correspondence from the registry?
Mr. Chairman, all we received was just a ruling. There's no record of proceedings, Mr. Chairman. If they sent it, they should prove it that they sent record of proceedings.
Okay.
We don't have any record of proceedings except a ruling.
I will not send you record of proceedings. You don't have. Can you listen to me? The tribunal will not send you record of proceedings if you did not ask for it.
Yes, Mr. Chairman.
What we told the registry to send to you was the ruling we gave at the last adjourned case concerning your representation of your client. If you are failing receipt of it, because I'm aware that it was sent to you by the registry, I will read it out to you so that you can understand.
Yes, Mr. Chairman.
Okay?
Yes, Mr. Chairman.
I here to discuss all the parties. And I have to ask you whether you will actually be able to do justice to the cross-examination. That's what we asked you. Did you obtain the record of proceedings? Did you review to know the evidence that was given to you by the witness? Which you said you did not receive. And I was asking you, if you are a diligent counsel, you missed a hearing date, trial proceeded, the tribunal gave a ruling, and we adjourned to today for cross-examination by yourself. Should you not have asked for the record of proceedings to know what transpired at the tribunal that day? Okay. I will begin what we do. Well, I will do on the other on the 19th of May, actually, was the date. But that's 2 months ago. This appeal was filed by way of summary appeal procedure on 29th March 2022. Following the order of the tribunal, the appellant filed the appeal by way of notice of appeal on 16 September 2025. The third respondent was not absented on a few occasions that the appeal was going on. By letter of 5th December 2025, the third respondent's counsel sought for an adjournment, which we honored. Fast forward to 24th February 2026, the third respondent sought an adjournment to file an amended reply to the appellant's notice of appeal, which the tribunal honored by adjourning further proceedings in the appeal to Wednesday, 23rd April 2026. It is on record that the third respondent's counsel did not show up on the adjourned dates on the ground that she had just been reliably informed that the case was so adjourned as recorded in an email of 22nd April 2026. Even though she was physically present here when we adjourned the appeal at our request, the tribunal did not follow our request for the appeal to be adjourned to the end of May 2026, as it did not fit into the schedule of the tribunal. We accordingly directed the registrar to notify her of today's adjourned date with a note of caution that the hearing in this appeal will proceed, whether or not she is present. This morning at 9:29 a.m., she sent an email to the registrar requesting for an adjournment of this appeal to a convenient date between 18th and 23rd June or between 29th and 30th June 2026. We deny this request for the following reasons. Number one, the third respondent's counsel has not shown due respect to this tribunal and are colleagues representing the appellant and the first and second respondents. The tribunal does not sit at the convenience of counsel on their parties. The third respondent's counsel has not shown sufficient diligence in prosecuting this appeal by a persistent request for adjournments and by failure to file the so-called amended reply, for which reason she sought an adjournment at our sitting on 24th February 2026. The third respondent's counsel cannot hold the tribunal and other parties in this case and their counsel hostage by our inertia. Justice must not only be done, but must be seen to be done. The appellant and other parties in this case deserve justice, and it will be unfair to them for the tribunal to adjourn this appeal at the request of the third respondent counsel. Accordingly, the tribunal hereby grants the prayer of the appellant to open its case. The registrar is again directed to work process and transmit a copy of this ruling to the third respondent's counsel, with the other counsel in this case representing the appellant and the first and second respondents in copy. I hope you heard us. I hope you heard what I just read.
Yes, Mr. Chairman. Mr. Chairman, we don't intend to disrespect the court, the tribunal. We apologize. And we were trying to also put our house in order. And along the line, the dates were clashing with other matters when we're asking for adjournments. Not to disrespect the tribunal, my lord. We apologize, my lord.
Okay, now, we want to give a directive now, and order. We will not allow you to cross-examine virtually. Do you understand? You have to be at this tribunal. Because of correct use. Do you understand? So we are going to adjourn this case now to 13th of August, and you should be physically present here.
Yes, as the court pleases, my lord. We are most grateful.
Counsel for appellant, please. Review your guidelines. You're not even for.
13th of August.
One person is supposed to be in the one person is not really. Prepare the question. Finish our gist everything. One day family wedding outside Nigeria. And then we later one person from her family. And later I'm not even going. Discuss with me. Prepare my question. Just pick up. Tribunal is taking records. Okay.
Correspondence cancelled. How that is. Are you happy? Can you confirm that they can hear us clearly as I speak now.
I can hear you clearly, Mr. Chairman.
The third
I can
respondent
hear you
council,
clearly, Mr. Chairman.
the third respondent council was prepared for the cross-examination of the appellant's witness. In this case, even though the tribunal, even though she told the tribunal that she wanted to proceed, please can you keep quiet? Can you mute yourself there, because the noise is coming from your background there. Okay. The third respondent council was unprepared for the cross-examination of the appellant's witness in this case, even though she told the tribunal that she wanted to proceed. However, having been absent from the last proceedings, we expected her to have applied for the record of proceedings on the last adjourned date, so as to know the evidence given by the appellant's witness for her to effectively cross-examine her. Not having done so, we do not see how the third respondent council can do justice to her client by cross-examining the appellant's witness when she did not know the evidence given by the witness. Our virtual attendance today on the Zoom platform was ineffective, as there were network connectivity issues that made effective communication between her and the tribunal, and vice versa ineffective. Accordingly, the tribunal hereby directs the tribunal hereby directs all respondents council to appear in person on the next adjourned date to cross-examine the appellant's witness. Accordingly, further hearing in this appeal being and is hereby adjourned to Thursday, 13th August 2026. The tribunal so ruled. Now she's out of the screen.
I'm not just real.
Let's just hold on for 2 minutes so that she will comment. Okay. Mr. Akini Fesi,
Yes, Mr. Chairman.
what you had the ruling of the tribunal?
That we should apply for the record of proceedings and come in person on the 13th of August, Mr. Chairman, to cross-examine the appellant witness.
All right, at least you got it. So we just want to see you on the 13th of August. In person.
I didn't get that, Mr. Chairman.
We look forward to seeing you on the 13th of August in person. So cross-examine the appellant.
We'll be in court, Mr. Chairman. On the 13th of August.
All right, see you later. Thank you.
I'm sorry. I just want to bring you to the tribunal. So that's
Your intent to disrespect the court.
Right. No, I think she wants to say something. Right.
Okay. We apologize to the tribunal and to my colleagues that we do not intend to disrespect the tribunal or delay proceedings. So please accept our apologies, my lord. We'll be in court on the next date to cross-examine the appellant's witness. Why would I have applied for the record of proceedings? Thank you, Mr. Chairman.
I just want to bring to the that on 19th day of 2026, we served with a motion seeking the review of the honorable. By now, I'm quite aware that has not been moved by the first and second respondent council. Somebody called respondent and I did not preparation to appear before the tribunal. So I wouldn't know if my honest friend. So we always start that process so that at least we know what we are actually coming to do and how to make progress in this matter.
But you're not for the first and second respondent now. They should speak for themselves. You're for the appellant, if I'm correct.
You know, I just don't want to be having issues with the third respondent counsel. Like today, ordinarily, I should have actually been an application that she should be foreclosed. Because we have actually been having adjournments at instances. And that's just the only reason why I raised this issue. Whether or not she's actually aware that this process has already been served on her. So that we won't come back next time and she'll be saying that she has not seen the process before. That's the only reason why I'm raising it.
Okay, thank you. So, Mr. Akele, first, did you receive?
Yes, Mr. Chairman.
Receive a motion dated 19th of June 2026. Was dated 18th June 2026, but filed on the 19th of June 2026 from the first and second respondent counsel. Because we couldn't move that motion on that day due to your absence.
I know we've received it.
Where you are being asked, where the tribunal is being asked for leave to summon the third respondent, the Cartagena Federation, to appear before the tribunal to tender a letter dated 4/10/2024. So you receive the motion.
Yes, Mr. Chairman.
All right. So
I know the
you say
same
the motion.
documents was pleaded already. And we are not denying the documents. It's been pleaded by parties.
You have to repeat yourself because we don't have.
Mr. Chairman, I said the document was pleaded by the first and second respondents. And they were not denying the fact that it didn't emanate from us. So I don't know why the appellant is showing interest. He didn't plead those documents. It's the first and second respondent. And we are not denying that it didn't emanate from us.
Okay, all right. We'll take the motion on the next item, please. That's the point your colleague here, Mr. Abdul-Rafiq, was making. He wanted to make sure that you have received the motion. So that's the point he was making, okay? So we'll take the motion on the next item.
Yes, Mr. Chairman.
The first and second respondents motion dated 18th June 2026 and filed on 19th June 2026, seeking leave of the tribunal to summon the third respondent to appear and tell that the letter dated 4th January 2024 will equally be taken on the next agenda. The tribunal so wish. All right, then ambulance counsel. And the last agenda, we made reference to certain documents that were not clear, which we asked you to provide.
Such a say about this, and say about this. I just remember now, and say about this. We have a copy of those documents. I'll make it available for us. I think it's very important.
Okay, make them available to the registry so that they can be put on the file. And at the same time, share the clear copies with your colleagues.
I'll tell you.
Mr. Akini Percy and Deborah Obedema. You can take him on the tribunal in this case, it's like join your mother. And Mr. Duyale will also discharge you for the moment.
Yes, Mr. Chairman.
Or I see you on the 13th of August, same journey to Ibadan from Abuja. Mr. Duyale.
Oh, thank you, Mr. Chairman.
All right, all the best. And Mr. Duyale will discharge you as well for the moment. So come in person on the next agenda. So appear.
Yes, Mr. Chairman.
Mr. Duyale, we want to make sure that you have the council can hear us. You need to appear in person on the next agenda for your first submission.
Okay, that's a good one. What do you consider she should appear in person?
Yes.
You need to appear in person on the next agenda date for your first examination.
Yes, I will, sir.
All right, we discharge you for the call.
Mr. Chairman. Okay. You just a sip of tongue sometimes.
It's all the next sentence.
So TAT/ID/084/2025. Two metals Nigeria Limited versus Federal Aluminum Limited. Active. Okay. Attendance.
That would be for the person.
Especially, I'm FD for Chalet. Apparently, it's IP. Appearance correspondence.
Not there, no, not there.
Stanley, right?
Yes.
That's it, always fair.
Who's appearance?
IP. You know, as at the last received it on June 25. After the proceedings, our witness confirmed that initially confirmed that the unavailable in the tribunal today. But as at Monday of this week, he actually reached out that who was that would actually make it. After we reached out to the registry of this tribunal, and we were then informed by the registry that the council, the appellant, had already made an application that do the tribunals.
You actually want that side, right, from them. You have another side of the state, separate, like, sit like, this one there. It's not the applicant that apply for, I know. I just don't know.
That will happen.
Yeah,
Initial is you can say no part now, fair enough, and two visible. You can now say. Visible.
yeah, I did like that, I believe it's a second July. And I believe you have served your. But it on the other side. Yeah, but that's not the problem. Yeah, so. Correct, so we have right now. It's that consensus. I think that's cancel this man. Do some better houses. For same 13th of August. That last person not appear today on the basis of the respondent's counsel stated. Of 2nd July, seeking adjournment, further hearing is appeal. Is hereby adjourned to Thursday, 13th of August, 2026. It shall be on the general basis. Please call the next appeal.
TAT/IP/079/2024. Ogun State Internal Revenue Service was of Federal's Limited. Parties.
No balance for the. Appellant. What are the department? What is it? What are the services of half money?
Appeal.
That's just responsive. Appearance for the applicant.
So, we've not been able to engage the legal practitioners or this. From the last person, I understood someone is for examining the appellant witness. I was not able to attend the last sitting because I was involved on filing the landmark and it was towards the deadline of filing. So I had to tell my colleague to represent us for the financing, time company. Then it's certificate data. So I was informed that I need to be around to process that appellant.
You receive the correspondence of the registry.
Yes.
So. After the question of this.
Our witness is nonsense at the tribunal this morning. He called me yesterday that he was indisposed. And from the disposition of the respondents, I didn't want to bother him to tribunal today. Let him know that he informed nothing was done.
I didn't want to
Your Honor, because there have been no representation for the respondents in the last 3 to 4 adjournments. So that was why I told him to stay back before that. We'll be at this tribunal on 12th August. If it's convenient, we will be at the tribunal. Well, we apologize for his absence this morning.
See that we started right there. There's that sound. That's yes, sir. But yeah. Okay.
Finish your lesson. Have you completed your previous?
Yes.
It's like, twelve photos, that confident for you. So come on, process everything, it's out of 6%. No, for you, girls. So process everything,
Yes, I'll be available.
you know what to do before then. Why do you want to process that? Most more you are not invited. So your company has policy to engage a replacement lawyer since February, because I think February was when your last lawyer was through.
All right.
For 4 months, your company of thousands of lawyers in Lagos and in this country.
The economic family and the president, so which make it difficult for them to engage on that stuff.
All right. Okay. So, because you are a layman, and just like my comment, I have this. You cannot cross-examine a witness when you don't know the evidence and the witness has it. You understand? So, you should apply to the registry to give you a record of proceedings where the appellant witness gave advice. So you read it as basis for your cross-examination, along with the witness statement and post that was filed. Okay, so that's what you need to do. We're telling you this because the layman wants to take control of the lawyer.
Can you write what my time I said it because you forget?
I understand what you said.
You need to come and you need to apply the registry to know what happened what questions they ask the witness, and the documents that were tendered, and the witness set of oath. You will review them for the next day. Based on what you see there, that's what you now base your questions on. Okay. So if I were you, I would write that. Now, meet. And
Other than this agreement is adjourned to Wednesday, 12th of August 2026. When the appellant to present his witness for cross-examination by the respondent. The respondent is directed to a different part of this case. where the evidence of the appellant's witness was taken to give it the sound basis for his first examination at the next item. This ordinance, that's fine.
First of all, TAG/IB/080/2024. Ogun State Internal Revenue Service versus December for West African package.
Thank you, General Treasurer. CR. Then statutes that outside. You all know what's the dates.
How about that's for that?
The respondent absence. Passport,
Well, yes.
not yours. And last I done with Mr. Eggers, the respondent's counsel. Period with the tribunal for the further adjournments. And we also have thought that we was going to file in response to our notice of appeal or seek settlements with the appellants. And that was on 18th May 2026. Till date, there has been he has not fulfilled any of his prayers before the court, either a response to our appeal or approaching the appellants for a settlement. When in view of that, I will be asking for applying for the leave of the honorary post to conclude on the respondents. And then also to give us grant us leave to file our final reason address case.
Well,
Most grateful.
As the, on due delay, in the prosecution of this appeal, which is due likely to be filed for the respondent and his counsel. We adjourned this appeal since the 18th May 2026 to today, to enable the respondent's counsel to either file a compliance with notice of appeal, or the basis his client's attention before this appeal, in the event that they are not willing to pursue out of tribunal settlement. The court examined the appellant's request by the last adjourned date and had no objection to the appellant's counsel's application to close our client's case today in the event that the respondent or his counsel is not at the tribunal. And have not filed a reply to the notice of appeal. Accordingly, we have by now the prayer of appellant's counsel to close the appellant's case. Further to which we hereby conclude the respondent's case and grant leave to the appellant to file its final written address. The tribunal solution. The tribunal case. So, next item is. So what we are looking for, first, identity to how many is young fire? It's members. What are your tests?
Subject to the coordinate of the time.
We're going to provide this, what is, you know.
Yeah, we all need.
Yeah, that's only the two, my test of test. Is that awesome?
That, yes, that's right, that, working on them.
Okay. All right, so. You're asking my comment, Mr. Trevor. On where?
Subject to the, from the.
I will-
Any date is sent to the.
Asking this, I want to. On that, chapter, this, after this.
How much student fees have been dispersed for the.
That's really what's up, what's up, what's up.